Today, we're going to introduce the notion of impracticability in contracting. We've earlier discussed a host of formation defenses that are judged at the time of contract formation, but impracticability is a post-formation defense that can discharge contractual duties for events occurring after a contract is formed. To learn about impracticability doctrine, we examine U.S. versus Wegematic Corporation, a case decided by the Second Circuit in 1966. Back in 1956, when computers were still relatively new, immense, mysterious technologies, the Federal Reserve Bank invited companies to submit proposals for an electronic digital computing system. It stressed in its invitations the need for early delivery. Wegematic Corporation, which had recently produced a successful computing system, the ALWAC 3E, but which nevertheless was a relative newcomer to the industry, submitted the winning proposal. The Federal Reserve Bank and Wegematic agreed to a contract, under the terms of which Wegematic would deliver by June 30th, 1957, 9 months hence, a new computer model, the ALWAC 800. Wegematic proclaimed this would be, quote, a truly revolutionary system utilizing all of the latest technological advances. The Federal Reserve Board agreed to pay $231,000 for the ALWAC 800. Additionally, the contract provided that Wegematic would pay liquidated damages of $100 per day for every day that delivery of the computer was delayed, and that if Wegematic failed to comply with any provisions of the agreement, the board may procure the services described in the contract from other sources and hold the contractor responsible for any excess cost occasioned thereby. Problems weren't long in coming. In March, a few months before the delivery date, Wegematic suggested postponing delivery. The next month, the company wrote a letter to the board stating that due to the need for redesign, delivery would be delayed from June 30th until October 30th. The letter also requested waiver of the liquidated damages clause. The board took the requests under advisement. On August 30th, 1957, Wegematic wrote to the board that delivery would be delayed, quote, possibly into 1959, unquote, well over a year hence, and suggested use of its ALWAC 3E equipment until then, and again requested waiver of the liquidated damages clause. The board did not agree to the waiver. The nail in the coffin came in October when Wegematic informed the board that due to engineering difficulties, it has become impracticable to deliver the ALWAC 800 computing system at this time. The board managed to secure another manufacturer, and about a year after Wegematic's announcement, IBM delivered to the board a computing system serving substantially the same functions as Wegematic's proposed ALWAC 800. The rental price for the IBM system was $102,000 per year, with an option to purchase the equipment for $410,000. In accordance with the terms of their contract, the board sought damages from Wegematic. A court awarded the board $46,300 for delay under the liquidated damages clause, $179,000 for the excess cost of the IBM equipment, and $10,000 for preparatory expenses that proved useless in operating the IBM system, a total of more than $235,000 in damages plus interest. Wegematic's sole defense was impracticability. It argued that delivery was made impossible by basic engineering difficulties, whose correction would have taken between 1 and 2 years and would have cost between $1 million and $1.5 million, and the success of which was not certain. In making this claim, the company relied on UCC Section 2615. That provision, governing excuse by failure of presupposed conditions, provides in part that, except so far as a seller may have assumed a greater obligation, delay in delivery or non-delivery in whole or in part by a seller is not a breach of his duty under a contract for sale if performance as agreed has been made impracticable by the occurrence of a contingency, the non-occurrence of which was a basic assumption on which the contract was made. The court, in an opinion by the well-known Judge Henry Friendly, agreed that the UCC was the proper guidance to seek on the matter, but denied that the engineering difficulties preventing Wegematic from achieving its revolutionary computing breakthrough could constitute impracticability. Specifically, the court asserted, quote, "We see no basis for thinking that when an electronic system is promoted by its manufacturer as a revolutionary breakthrough, the risk of the revolution's occurrence falls on the purchaser. The reasonable supposition is that it has already occurred, or at least the manufacturer is assuring the purchaser that it will be found to have when the machine is assembled." The court explained the negative implications that would follow from the defendant's argument. Such a policy would allow manufacturers to express what are only aspirations in order to induce agreements and gamble on mere probabilities of fulfillment without any risk of liability. Additionally, the court believed that the contractual terms and language placed the risk that Wegematic would be able to achieve its revolutionary breakthrough squarely on Wegematic. It noted the provisions allowing for liquidated damages and providing that the Federal Reserve Bank could look to other sources in case of non-delivery. Judge Friendly also decided that, quote, "If a manufacturer wishes to be relieved of the risk that what looks good on paper may not prove so good in hardware, the appropriate exculpatory language is well known and often used," unquote. So, what is the exculpatory language that the judge is referring to? His claim that there exists an altering rule from the default rule that places risk on the seller, an altering rule that not only exists but is often used, comes without any citation or support. And legal scholars have not identified what the words the judge had in mind might be. It's rather difficult indeed to imagine any parties conditioning a contract on the occurrence of a technological revolution, much less doing so often. One problem is that it's going to be very difficult for contractors to prove to a court whether a technological revolution has occurred. In the words of Gil Scott Heron, the revolution will not be televised. But Judge Friendly should at least be given credit for seeing that the doctrine of impracticability, like the mistake doctrines that we studied earlier, are merely defaults that the parties should be able to contract around. Indeed, both the impracticability and the mistake doctrines can be seen as default conditions to every contractual promise. Unless otherwise agreed, a promise to perform is conditioned on the parties not being mistaken at the time of formation as to a basic assumption, and is also conditioned on the non-occurrence of contingencies whose non-occurrence was a basic assumption on which the contract was made. What kinds of scenarios do you think the UCC contemplates in 2.615 as being the types of contingency whose non-occurrence was a basic assumption on which the contract was made? Well, one example of a successful claim under UCC 2.615 is Red River Commodities Incorporated versus Ayres, where the plaintiff sued Ayres for breach because he failed to deliver 250,000 pounds of sunflowers as required by the contract. Due to a drought, Ayres only produced 75,000 pounds. Because a provision in the contract excused the parties from performance if fire, strikes, accidents, acts of God, and public enemy or other causes beyond the control of the parties took place, the court determined that non-occurrence of a crop-destroying drought was a basic assumption on which the contract was made and excused Ayres' performance based on UCC Section 2.615. The court's reliance in Red River Commodities on the particulars of a contractual clause offering excuses for non-performance is important. Normally, a contracting party will not be excused under the contract default clause or standard risk allocation clauses unless the clause provides for such an excuse. By the way, the act of God clause has been sometimes defined as an act of God as an act that no reasonable God would do. It's hurricanes and other weather misfortunes. How does the UCC's impracticability provision compare to the mutual mistake doctrine we covered earlier in the course? One important difference is that the UCC seems to contemplate circumstances that arise after the parties have already formed an agreement, while mutual mistake, the mistaken assumption, exists at the time the contract is formed. Notably, the restatement has two impracticability provisions. Section 261, which governs supervening impracticability, and it closely mirrors the UCC's provision. And then there's a second provision, Section 266, which concerns existing impracticability. This provision is much closer to mutual mistake. One difference is that under the existing impracticability provision, no duty to perform arises if the conditions are met, while under the mutual mistake provision, a duty arises which is voidable by one party. But in both cases, if the defense is properly invoked, there is no enforceable duty and the remedy is restitution. Another difference is that the impracticability provision doesn't contain the, quote, assumption of risk language that the mutual mistake provision contains. However, the restatement, Section 266, does say that the provision doesn't apply if language or circumstances indicate contrary, which might produce the same default-like result. So, what have we learned? We introduced the concept of impracticability and examined not only the UCC's provision concerning impracticability present in the Wegematic case, but also the restatement definitions. We compared this new doctrine with a now familiar one, mutual mistake, and we had occasion again to revisit the concepts of assumption of risk and default and altering rules, and the possible policy consequences of such rules. Finally, looking back at the mastodonic computers of the 1950s, from the age of the smartphone that we now